Okay, happy Thursday, everybody. We're going to go ahead and start our meeting, House Judiciary, today, Thursday, February 12th. I'm going to start off with just a little trivia question. Who knows what U.S. president is in the National Wrestling Hall of Fame? No? No. It's not the current president. Does anyone else? No, wait, hang on. Just any other ideas? Exactly. Okay, Lene, tell us who it is. Whose birthday is today. So happy birthday, Abe. So okay, we're still waiting on a few members, but we're going to go ahead and get started. We have a very full day. We have 3 bill hearings, and I have it is my goal to work 6 bills today, but we'll see what we get to. We'll do everything we can to get all of our work done and make sure everyone is heard. For all the proponents and opponents who are here, neutrals, I just want you to know that you will have 2 minutes, and I'm pretty flexible on the time, but at 2 minutes, I will interrupt you and ask you to wrap it up, just so you know that that's what the plan is for today. Okay, we're going to start off with a hearing on House Bill 2754. We'll call on Jason Thompson, our advisor, to give us a bill brief.
Thank you, Madam Chair. Good afternoon, committee. Jason Thompson, Office of Revisor of Statutes. 2754 enacts the Providing Civil Relief from Coerced Debt Act. It provides protections and remedies for victims of certain debts constituting a coerced debt because of actions by another individual within the context of domestic violence. The bill has 4 new sections of law to be known as the Providing Civil Relief from Coerced Debt Act. Section 1 is the name of the act and has a broad purpose statement. Section 2 is where you'll find definitions. I'll highlight coerced debt. That is a debt or a portion thereof that was incurred because of the following within the context of domestic violence as defined in our criminal code. And that would be identity theft, fraud, duress, intimidation, threat, force, coercion, manipulation, undue influence, misinformation, or the non-consensual use of the debtor's personally identifiable information. So any of those acts within the context of domestic violence can make a debt a coerced debt under the definitions. I will highlight that debt does not include an obligation or an alleged obligation to pay money secured by real property. So it would not include a mortgage, for example, but otherwise debt means exactly what you think it is, an obligation to pay money. There is a definition of economic abuse and perpetrator of coerced debt that I highlighted in the bill brief, but I won't read now. And then statement of coerced debt is another defined term that is a statement by a debtor to a creditor, either orally or in writing, that conveys information about the debt and is trying to tell the creditor and help them identify that that debt is coerced debt. And I highlight that statement of coerced debt because that comes up almost immediately in the next section. So then after the definitions, section 3 provides that within 10 business days after receipt of a debtor's statement of coerced debt that I was just talking about, the creditor shall notify any consumer reporting agency to which the creditor furnished adverse information about the debtor, that the debtor disputes that information, and that they're claiming it is a coerced debt. There is then a 10 business day time frame that kicks in, and there are certain actions the creditor needs to take. Those are all provided there in section 3. If the debtor provides to a creditor a statement that includes some but not all of the required information, then the creditor has 5 business days to notify the debtor that there is additional information needed and starts that aspect of the process. That's also found in section 4. And then I'll also highlight in section 4 that the Office of the State Bank Commissioner is required to make a standard form that would be used for these purposes. And they're doing that in collaboration with the group that created the Model Act that this is based on, the National Consumer Law Center. So highlight that from section 3. Then finally, section 4 is all about sort of the remedies for coerced debt. It provides that a debtor is not liable for a coerced debt. They can raise that defense in any forum. They can establish their case that it's coerced debt by providing certain information and documentation. And there's a process for figuring out whether it is coerced debt or not. There's also a clear statement that if you can identify the perpetrator of the coerced debt, then the creditor should go after that person to collect the debt and use all legal rights and remedies available to collect the debt from that perpetrator. And then any creditor who fails to comply with any of the provisions of Section 3 about figuring out whether something is a coerced debt is liable for certain damages, including reasonable attorney fees and possibly even punitive damages in cases of willful noncompliance. So I wanted to highlight there is a penalty provision. This does apply to lawsuits filed in this state, regardless of whether the contract or the debt itself provides that the law of another state applies. So like if there's a choice of law provision, the law of our state is still going to apply under a special provision in Section 4. I think that covers very broadly a fairly dense 4 new sections. And I should point out it takes effect on July 1st if you adopt it.
Okay, thank you, Jason. Committee members, what questions do you have for Jason about this bill? Okay, seeing none, thank you. Oh, I'm so sorry. I looked over there and I didn't see you. Okay, Representative
When you
Carmichael.
looked, I hadn't raised my hand. I was contemplating.
Oh, okay.
Mr. Revisor, just very basic thing. If it's found to be a coerced debt, does that excuse the debtor from payment?
Madam Chair and Representative, yes, there's a statement on page 5, line 6, right at the beginning of Section 4, a debtor is not liable for a coerced debt. So they will not be liable for it. The person that would be liable would be the perpetrator of the debt, and that's who should be sought.
Thank you.
You're welcome.
Okay, any other questions, committee? Okay, seeing none. Thank you, Jason. All right, we will go ahead. We have proponents, written opponents, and neutral testimony. We'll go ahead and start with the proponents. Andrea Bopp Stark, and she is on WebEx.
Great.
Tell me we have her. Yeah, okay. All right, thank you. Welcome to our committee. You have about 2 minutes.
Okay, thank you very much. Good afternoon, Chair Humphreys, Vice Chair Williams, and members of the committee. My name is Andrea Bopp Stark. I'm a senior attorney at the National Consumer Law Center. For over 50 years, NCLC has worked to protect the economic security of vulnerable households. I'm here today in strong support of HB 2754, a critical piece of legislation that addresses the devastating impact of coerced debt. Coerced debt occurs when an abuser uses threats, fraud, or manipulation to force a victim to incur debt, often without their knowledge. This is a pervasive tool of control in domestic violence, human trafficking, and elder abuse. Survivors are left with ruined credit, aggressive lawsuits, and wage garnishments. These financial scars often trap victims in a cycle of abuse because they cannot secure the housing or jobs needed to truly escape. Current consumer laws simply do not and were not designed for this reality, leaving survivors in expensive legal limbo with no guarantee of relief. While we have petitioned the federal government for change, federal rulemaking has stalled. It is now up to the states to lead, and this bill is grounded in a proven model law developed by the National Consumer Law Center. We know these protections work because we've helped pass them in states like Texas, Maine, and California. And in those states, we've seen a decrease in litigation. When debt collectors are presented with credible evidence of abuse, they routinely dismiss the claims, allowing survivors a fresh start without the need for a courtroom battle. This bill is a balanced, survivor-centered approach. It does not erase legitimate debt. It simply ensures survivors are no longer punished for the harm inflicted upon them. In fact, creditors retain the right to pursue the perpetrator, the person actually responsible for the debt. It shifts responsibility to the perpetrator where it belongs. We respectfully urge the committee to advance this bill, and I would refer to my much lengthier written testimony, and I'm happy to answer any questions. Thank you.
Okay, thank you so much. So if you will stay available, we'll have our one other proponent, and then we will ask questions of both of you. Okay, next we'll have Michelle McCormick, the Executive Director of the Kansas Coalition Against Sexual and Domestic Abuse. Welcome to committee. Nice to see you again.
Thank you, Madam Chair, members of the committee. Good to see you all again. Michelle McCormick, the Executive Director of the Kansas Coalition Against Sexual and Domestic Violence. Thank you for having me here today. You have my written testimony, which has a lot more detail, so I'll just hit the highlights and respect the time of the committee. Obviously, we are here. Over the years, I have brought many issues to you all, and we focused our efforts in order to support survivors and victims of domestic violence, and we've often focused on the physical aspects of what's going on in those relationships. But it is overwhelmingly the feedback of the victim advocates that we serve at the coalition and the survivors that we hear from every day that the economic abuse that they face is incredibly significant and has long-lasting impacts for their situations. And so that's why we're here today, starting this adventure into addressing and trying to find relief for economic abuse. And so we sought out the counsel of the National Council. I appreciate my colleagues' testimony. We asked for their assistance in order to find what would be the best solutions, but also adapted for Kansas. And so we're grateful for their support. And I want to be very clear that we agree, we do not think that this debt is the responsibility of the creditor. We're not asking, of course, for all debt for all victims of domestic violence to just disappear as like a magic solution to their challenges, but instead specifically and narrowly addressing coerced debt. And so when they can credibly demonstrate that the debt that was placed upon them was a tactic that often is intentionally used by their abusive partner in order to ensure financial dependence on the abuser, or to eliminate their opportunity to rent a new apartment, or to have economic stability. And so we are certainly asking for your support in order to address that. We think the processes that are outlined are fair to creditors, give relief to survivors, but then most importantly, assign the responsibility for this debt to the appropriate party. I am aware, I want to point you to some written testimony by one of our member programs and who tells a survivor story. But I also just want to mention that I've reviewed the opponent testimony, and we are amenable to any sort of suggestions that they have about language changes. So thank you so much for your time.
Okay, thank you so much. Committee, what questions do you have for our two proponents? Representative, we'll go Carmichael and then Barrett.
Thank you, Madam Chair. My question is for Ms. Stark. If you can hear me, ma'am?
Yes.
Good. I want you to understand I'm not necessarily an opponent of this bill at all. I just haven't had a chance to read and contemplate it. But let's take a circumstance where, say, my wife coerces me into signing a credit card application. It arrives, the credit cards arrive in the mail, even though I've been coerced to sign it. I then take the credit cards and I go out on a shopping spree. Or the context where my wife forces me to sign a loan agreement to buy a new Cadillac, and even though she's coerced me, I still drive the Cadillac for several years and benefit from it. How does this statute affect circumstances where the coerced debtor has benefited from the loan transaction?
Yeah, so that's a really good question, and there are a couple different answers because there's personal. You have the credit card, which is an unsecured debt, and then you have the car, which is a secured debt. So
Why I asked it that way?
yeah, very smart. So there is an opportunity for the creditor to go to court and challenge that this is coerced debt, and challenge that this debt should be waived and uncollectible or deemed uncollectible. So there is that specific remedy in here where the creditor can go into court and challenge the survivor's claims. So that's one opportunity for the creditor. Creditors who do collect on credit card debt are used to going to court. They know the process. This isn't a heavy lift for them. So it would be something that they could do if they felt that there was fraud or misrepresentation or some other claim that they may have to dispute the debt. And then with the car, I would say if the payments are not made, if you or your wife were to stop making those payments, the car could be repossessed and then sold and paid to, or sold
Okay.
to pay the debt.
That wasn't really what my question was, but I'll try to contact you tomorrow if you're available and we can discuss it further.
Oh, absolutely. Sorry, I didn't answer that.
Representative Barrett.
Thank you, Madam Chair, and to Mrs. Stark as well.
Okay. Yep.
Right. Ms. Stark, thank you for your testimony today. Agree 100%. Think it's a good bill. I guess my question would be, though, is when it comes to credible evidence, would that be like an arrest report for domestic violence against the victim's offender? I mean, what are some examples that you've seen in these other states as credible evidence?
Well, there is a list here in the bill of adequate documentation. If you want to look at section 1, let's see, section 2B, and it says adequate documentation, a police report, an FTC identity theft report. Is that what you're talking about, or you mean for the creditor to bring? I'm sorry.
Nope, I think that covers it.
Okay,
So
okay.
for the police report, I mean, is the report itself enough, or does it need to go through the
So
court process to
says-
show that he's convicted? Okay.
So it says a police report that identifies the coerced debt or a portion thereof and describes the circumstances under which the debt was incurred. And that police report, if a survivor is to provide a police report, that is made under oath, and if there is fraud or if there is some type of misrepresentation, then that can be brought to the court's attention as well. So police report, Fair Trade Commission identity theft report, also an order from the court of setting forth findings of economic abuse, and there's written verification from a qualified third party, and then it defines what a qualified third party is.
Makes sense. Thank you, Madam Chair.
You're welcome. I also have a question if you want to just stay on. The states that have enacted coerced debt protections that you mentioned, is this bill more or less the same, similar, the same? I mean, are there major differences, or is this more or less what they've enacted?
Very similar. Most states have based their laws on our model coerced debt bill, and that's what this has been based on. And just about every state, it's similar. Similar. There are some nuances in different states, but it is based on the same model.
Okay, thank you. Any other questions, committee? Okay, thank you. We appreciate you being here. We have proponent written only testimony from Amanda Myers with the Wichita Family Crisis Center. And we have opponent written only Larry Zimmerman from the Kansas Collection Attorney Association, and Francie Wayland, Government Relations and Public Policy for the PRA Group. And we have neutral testimony from Cale Beam. Cale, come on up to the podium. Welcome to our committee.
Thank you, Madam Chair and members of the committee. Appreciate the opportunity to appear before you today as a neutral conferee on House Bill 2754 on behalf of the Kansas Credit Union Association. We want to commend the committee for taking a deeper look at this important issue. Credit unions strongly support the goal of protecting consumers from coerced and illegitimate debt. And in cases of confirmed fraud or identity theft, we already routinely take action to unwind those debts. While we do appreciate the intent behind the bill, we do have some concerns that the bill as currently drafted contains some overly broad definitions and lacks important procedural safeguards that could lead to unintended consequences. As written, the bill does not require a clear objective trigger, such as a court order, to establish that a debt is illegitimate. Instead, the bill relies on a broad definition of adequate documentation, which could include the filing of a police report or identity theft report, even when no investigation occurs and no formal determination is made. The bill also allows a letter from any healthcare professional, member of clergy, or other third party to independently trigger creditor obligations, including pausing collections and refunding previously made payments without any formal investigation or adjudication. From a lender's perspective, this creates uncertainty around how and when obligations are triggered, even when a financial institution has acted in good faith and followed standard underwriting and compliance procedures. Credit unions are member-owned nonprofit cooperatives, and any losses are distributed among all the members. That said, when a member has been a victim of identity theft, we are committed to assisting them, and we support ceasing collections and correcting credit reports when the debt has been determined to be illegitimate. However, we believe that these significant obligations should be tied to a clear, objective determination. For that reason, we respectfully request the committee consider amendments that provide additional clarity and link creditor obligations to an objective trigger, such as a court order. This is similar to what Texas adopted last year. We've provided that language for the committee's reference, and currently working with the revisor on amendments. Don't have those ready today, but are happy to provide those when they are available. So with that, appreciate the opportunity to appear before you today and happy to answer any questions.
Okay, that sounds great. So yeah, just note, committee, that the Texas section is in your testimony also. Okay, do we have any questions for Cale from the committee? Okay, seeing none, I think we're good.
Thank you.
Thank you so much. This is a new subject for us on this committee, so I think we'll take it under consideration, and we'll see if we do work it, it would be on Monday, just so you all know that. Okay, we also have written neutral only testimony from Kelly Vanswell from the Kansas Bankers Association. Okay, since nobody else, okay, we will close the hearing on House Bill 2754. And we'll open the hearing on House Bill 2762 and ask our revisor for a bill brief.
Thank you again, Madam Chair. Jason Thompson, Office of Revisor of Statutes. House Bill 2762 modifies the crime of unlawful sexual relations to describe who is a person in a position of authority for a school. So the bill is amending KSA 21-5512, that is the crime of unlawful sexual relations. Under the current law, one offense under this crime is engaging in consensual sexual intercourse, lewd fondling, or touching, or sodomy with a person who is not married to the offender, if the offender is a teacher or other person in a position of authority, and the person with whom the offender is engaging in that conduct is a person 16 years of age or older who is a student enrolled at the school where the offender is employed. So the bill is adjusting that language, specifically about the teacher or person of authority in a school and a student, to include conduct, to specifically prohibit conduct when the offender is a teacher or other person in a position of authority for a school, and the person with whom the offender is engaging in such conduct is a student enrolled at such school. So not a lot of change in that language, but there's some key differences between the two. And you can see where that is adjusted on the top of page, bottom of page 2 onto the top of page 3. Then the other major change in the bill is adding a definition of person in a position of authority for a school, which is not a defined term in the current statute. And I think that's what you'll hear the testimony about. What does that mean and who does that cover? There is a definition in current law of teacher, and it's not at all necessarily what you would think. It's not changed in the bill, but teacher under this statute means and includes teachers, coaches, supervisors, principals, superintendents, and any other professional employee in any school. So the group of folks covered by the word teacher is pretty large. And then the question is, what does person of authority mean? So it is defined in the bill. There's a lot of new language. I point this out in the bill brief too. There's a lot of new language in the bill that's not new. We basically put the definitions in alphabetical order. So everything looks new, but the only one that's new and has any substantive change is person in a position of authority for a school, which is on page 5, beginning in line 24. So apologies for all the technical cleanup and all of the moving things around, but I promise the other things are not changed in any substantive way, just this. So person of authority means someone who's not a student at the school, is delegated authority by the school to interact with students, and is a volunteer for the school, is designated or assigned to provide services for the school, or is a contractor or an employee of a contractor who's under contract to provide services for the school. So a little bit more definition there about the folks we're talking about. It would take effect on July 1st if adopted. I'll answer questions if I can.
Okay, thank you. Thanks for explaining that, because it looked, yeah,
It
more,
looks like a lot of changes.
Mhm.
And we always ask when we're doing these bills, the
Mhm.
revisor would always like to do technical cleanup, make the statute cleaner, better, especially in the criminal code, put things in alphabetical order, put things where they belong. And we always defer to the requester, are you okay with that? Because it makes it look like you're doing a lot more in the bill than you really are. So all the request is really doing is changing that language on bottom of page 2, top of page 3, about how we define this particular offense, and then adding that new definition, person in a position of authority for a school, on page 5. That's really all the bill is doing, different from current law.
Okay, thank you. Very helpful. Representative Carmichael.
Thank you, Madam Chair. Once again, I'm generally favorably disposed to the bill, but Mr. Thompson, I can't even remember your name this afternoon. I'm sorry.
It has been a long week.
I am
Known
a
you for a
little
long time.
I am a little concerned about the clause involving delegated authority by the school to interact with students. By way of example, let's say the school district contracts with Acme Painting to send tradesmen out to paint. Their authority probably isn't to interact with students, but I don't know. Would misconduct by the tradesman contractor fall within the ambient of the bill?
Madam Chair and Representative, I think that is part of the reason for the breadth of the definition, because under certain circumstances, a contractor who's in the building for a long time and is given authority to interact with students, the policy choice from the drafters was to cover that person. If it's not interacting with students enough, then that would be a question of fact, and you might not want to cover that person under this crime. But I think the idea with this was to make it as broad as they could, to say if you are there under authority of the school to interact with students, this conduct is prohibited. Even if it would otherwise be consensual because the person is able to consent and you're an adult, it's still non-consensual for purposes of this statute. It's illegal, unlawful.
With respect, I think this proves to be words of limitation rather than words to broaden the scope, but that's just my view at this moment. Thank you.
Representative Vaughn.
Thank you, Madam Chair. With the definitions for a person in position of authority for a school, where it says not a student enrolled at the school, I just want to make sure that that would not be applied to, for example, a student enrolled at another school. Like if that person was in a relationship with someone at the school, for example. Does that make sense?
I think so. Thank you, Madam Chair and Representative. So the crime itself requires that you be a teacher or person of authority for a school, and the person you're engaging in the conduct with is a student enrolled at that school, at such school. So you have to be at the same school. And then the not a student is supposed to exclude students in that school that otherwise have authority. So they might be a position of authority because of something the school has done to make them, a student with authority. And so I think it's meant to carve them out. If you're a student from another school and you've somehow come into this school and been given authority, I think we might have some questions of fact I need to sort through if that's where you were headed. So, there is also, going down this rabbit hole very briefly and off the cuff, there is a specific crime related to interaction between, consenting minors, right? So that would have to be factored in too. So it gets a little complicated pretty fast, unfortunately.
But it does sound like not a student enrolled at the school is like a subcategory of a person in a position of authority. So like both of those conditions have to be met.
Yes, if I missed the mark on the question, yes, the list on page 5 for this definition is an and. It's A, not a student, B, delegated authority, and C meets one of those other things. It's got to be all three of those things.
Okay, thank you. Any other question? Representative Goddard.
Thank you, Madam Chair. Is a homeschool child who participates in extracurricular activities, for example, they play sports, and they interact with a coach, is that covered under this bill? Are they enrolled in that school?
Madam Chair, Representative, my understanding of enrolled at the school, no. They would not be enrolled at that school.
So they're basically unprotected.
Madam Chair, so for purposes of this bill, I'm looking to see if there was another exception that, or another offense that might apply, but this education offense at least does not. But there might be other crimes that are applicable, and I'm just not sure off the top of my head.
You have a follow-up, Representative?
I think that answers my question. I don't know if I like the answer or
Okay,
not.
yeah.
Thank you, Madam Chair.
Okay, Representative Schreiber.
Thank you, Madam Chair, and thank you, Jason. Just a quick question. I was looking through the definitions, and there's a definition on line 34 and page 5. Sanctions house, and it refers back to a statute 382302. When I went to 382302, I didn't see that described or anything. Can you tell me what that is, or?
Madam Chair, Representative, I'll have to double check that cross-reference. That is one of the ones in current law, and there should be a definition of that over there. Or maybe it's moved, but that's the revised.
Maybe it's not updated online.
Yeah, I mean, that's the revised juvenile offender code. That's what that's referencing, 3823. And maybe we've done away with the sanctions house definition, but I should also look and see where it's used in this bill, because I know that one is a provision specifically for folks who are in juvenile offender custody or interacting with the secretary or any of that sort of thing. There's a prohibition related to them, and that's what that definition is for. So let me double check. There may be an error that we didn't know because we were just keeping current law, but.
Okay, you can let us know maybe in just a little bit. Okay, any other questions? Okay, seeing none, we'll go ahead and go to our one proponent, Chip Root, Under Sheriff, Cherokee County Sheriff's Office. Thank you for being here and welcome to our committee. And we'll give you about 2 minutes.
Good afternoon, Madam Chair and members of this committee. Thank you very much for the opportunity to appear before you today. To voice my support for House Bill 2762, and I'm asking for your support of that very bill as well. Our goal is to close an unintended loophole in the current statute, as you have heard this afternoon. And long story short, the issue for me is when you have a person such as an SRO or school resource officer or a nurse or bus driver or other contracted employees that are not directly employed by, excuse me, the school. However, their day-to-day activities are to provide whatever resources or instruction or counseling or whatever, what have you, to the student. And this has been it's a glaring loophole for us. We've had issues with this, and we're just trying to ask for that support to close that loophole in this bill. And I'd stand for any questions.
Okay, thank you. I appreciate your explanation. That was very helpful. Committee, we have questions. One from Representative Barrett.
Thank you, Madam Chair. Hey, thank you for testifying on this today, Under Sheriff. And you don't have to go into detail, but this did come up because of a specific situation in your county where an individual potentially would have gotten away with a crime who was serving in a school because of that loophole, correct?
That's correct.
Okay, thank you. Any other questions from the committee or the Under Sheriff? Okay, seeing none. Thank you. We appreciate you coming to Topeka and testifying. Yep. Okay, committee, we also have proponent written only testimony from Jeff Easter from Sedgwick County with the Kansas Association of Chiefs of Police, Sheriff's Association, and Peace Officers Association. And that's all we have as far as conferees for House Bill 2762. So I'll go ahead and close the hearing on House Bill 2762. And we will open the hearing on House Bill 2688 and ask Jason to give us a bill brief.
Thank you again, Madam Chair. Once again, Jason Thompson, Office of Revisor of Statutes. House Bill 2688 provides that a non-disclosure agreement by any party in an action related to childhood sexual abuse or human trafficking shall not be judicially enforceable in a dispute involving childhood sexual abuse or human trafficking allegations or claims. The bill is a new section of law that would provide that an NDA, a non-disclosure agreement, by any party in an action related to childhood sexual abuse as defined in the civil code or human trafficking as defined in the criminal code shall not be judicially enforceable in a dispute involving allegations or claims relating to that conduct and shall be void. The section would apply to an NDA entered into before, on, or after the effective date of July 1st, so it is retroactive, except there is a mechanism for a person or a party to attempt to enforce an NDA entered into before the effective date if they go to a court of proper jurisdiction and obtain a declaratory judgment that declares the agreement or provision is enforceable. So there is retroactivity, but also a mechanism for certain agreements to be found by a court to be still valid if they're done before the effective date of the act. I think that's it for me. Be happy to answer questions if I can.
Okay, committee, what questions do you have for Jason? Okay, seeing none. Thank you. We'll go ahead and start with our proponents. We're going to go just out of order. We have Elizabeth Phillips with No More Victims. She was asking if she could go first. She's on WebEx. So we're going to go ahead. Tell me we have Elizabeth. Okay, great. Okay, so Elizabeth, welcome to committee. You are up first as far as the proponents go.
Thank you so much, and good afternoon, Chair Humphreys and committee members. Thank you for the opportunity to join you remotely today. My name is Elizabeth Phillips. I'm from Dallas, Texas, and I'm here to testify on behalf of my late brother, Trey Carlock, the namesake of House Bill 2688, which I very strongly support. I want to thank Vice Chair Williams and Representatives Bohai, Barrett, and Lewis for co-sponsoring this legislation to make the protection of victims' voices a priority in the state of Kansas. This bill ends the misuse of NDAs against child sexual abuse and trafficking victims in Kansas civil courts. My little brother, Trey, was abused at Kanakuk Ministries, a summer camp conglomerate based in Southwest Missouri. Kansas is one of their top markets. It's so encouraging that Kansas is joining a national movement to end the weaponization of NDAs against children that have already endured the unimaginable. I call it institutional abuse on top of sexual abuse. The legislatures of Texas, Missouri, Alabama, Tennessee, California have enacted laws so that silence is no longer for sale in civil settlement agreements pertaining to childhood sexual abuse cases. Kids should not be put under contracts, and childhood sexual abuse is shaming and silencing enough on its own. Survivors should never be forced to sign away their voices in exchange for settlement dollars they need for a lifetime of healing. Although this has become a standard practice in personal injury law, this committee can be the start of change in Kansas to say enough is enough. These are not slip and falls or construction and auto accidents. Childhood sexual abuse is trauma. It's an injury to the brain, body, and soul, and lawmakers must bring an end to the ongoing abuse of the system in these cases when victims seek civil justice. Let me outline how this happens, how it happened to my brother. Trey was groomed and abused from the age of 7 to 17 by a serial sex offender and Kanakuk director named Pete Newman. Newman has victims in Kansas, all over the US, and other parts of the world.
And Elizabeth, I know 2 minutes go so fast. I'm sorry, but if you could, you have time, if you could kind of move towards wrapping it up. Thank you.
Yes, ma'am. Because of Kanakuk's intimidating legal tactics and the NDA that was involved in the civil settlement process, I learned more about my brother's abuse and his death than I knew in his life. He died by suicide in 2019 because he could not heal after his voice was taken on top of his innocence. So we are asking that you join this national movement to end the misuse of NDAs, which were created to protect trade secrets, not trauma secrets. By doing that, you will honor Trey's life and legacy. You will bring darkness to light. You will give victims their voices back. And I thank you for your willingness to take this matter up. And I'm here also to take any questions.
Thank you, Elizabeth, and we appreciate what you're doing for your brother. Can you stay on for questions, or do you need to get off and so we can ask you questions now? What's your preference?
I can stay on. Thank
You
you.
can stay on, okay. All right, thank you. Okay, next we have Catherine Robb from Enough Abuse, and she's also on WebEx. Okay.
Thank you. Thank you, Madam Chair and members of the Judiciary Committee. My name is Catherine Robb, and I'm the National Director of the Children's Justice Campaign at Enough Abuse. I'm a national expert on child prevention legislation, and I am, of course, testifying in support of this bill, 2688. We're living in an epidemic of child sexual abuse. The best data tells us right now that 1 in 8 children will be sexually assaulted before their 18th birthday. All children are affected. This epidemic doesn't discriminate. An additional burden and danger is this problem about NDAs. They're just improper. Historically, they were used to protect confidential business data, trade secrets, and sensitive work data. And that, of course, makes sense. But they were not created to cover up sexual crimes and wrongs against children. NDAs, and this is probably the most important part of my testimony here, that NDAs for child sexual abuse are contrary to sound public policy, and they're dangerous for children. They silence victims and survivors just as Trey was silenced. They re-victimize victims, impeding real true healing, and it takes victims decades to come forward and find their voice. NDAs just take their voice away. Most importantly, they endanger our children now by 1, shielding sexual predators, covering up prosecutable crimes, mostly felonies against children, and concealing the negligent acts and practices of institutions and YSOs. Secrets serve sexual predators, not victims. Silence protects sexual predators, not our children. Thank you for your time, and I'm happy to take any questions.
Thank you so much. We now have the Reverend Ben Marquez, and welcome to our committee.
Madam Chair, members of the committee, thank you. My wife said she was yielding her time, Madam Chair, if that makes it. Mine won't be long.
Okay.
Thank you for the opportunity to speak in favor of House Bill 2688. My name is Ben Marquez. I'm here with my wife, Ashley. I'm an ordained minister in the Presbyterian Church in America, also known as the PCA. I'm currently serving as the associate pastor of Heartland Community Church in Wichita, Kansas. I am in support of House Bill number 2688, as it is my hope that this legislation will protect victims of childhood sexual abuse and human trafficking allegations or claims against those who would seek to use an NDA in an effort to silence these victims. The reason I'm here today is because, more personally, a number of years ago, I served at a church in Wichita, Kansas called Eastminster Presbyterian Church from 2013 to 2022. On May 31st, I was called by one of the elders from the church saying that I was being put on administrative leave, that I was relieved of all my pastoral duties. I was essentially fired, and I was fired for trying to help the church maintain integrity and transparency over a series of events that had transpired over the previous year. Not sexual assault, but other issues that were going on at the time. Anyway, 8 days later, I found out why they had given me no reason for why they were firing me. It's because they handed me an NDA that, in God's grace, my wife and I had the prudence not to sign because it was being offered as a bribe. And that is my contribution to you today. I have given you all a copy of the NDA I was given so that you might see how they are used against victims of sexual assault. I will just read one line for you to hear. You further agree not to disclose the terms or the existence of this agreement. Perhaps you understand what Elizabeth Phillips' brother Trey had to endure when he couldn't share what he knew about what happened to him, even with his own counselor. And so I was given that in 2022. We didn't sign it. And 2 years later, in 2024, another gentleman who will speak to you today by the name of Tyson Stewart, he came forth and his story came out about the abuse he endured under Bodie Weiss, who was a gentleman who worked at the same church I worked at from the late 1980s to 2006. Tyson went public, and then another gentleman who was in a Bible study I led at the church those years I was there came and asked me if I had heard about the story. I said yes. And he said, I also was a victim of Bodie Wise. And so I contacted the acting interim pastor at Eastminster Church, along with the associate pastor, a gentleman I had served alongside for almost 8 years. And I had lunch with them on August 20th, 2024. I told them to reach out to any of the known victims of Bodie Wise to extend their deepest sympathies for the evil that they endured at the hands of this evil man. And then I asked them to publicly repent of their use of non-disclosures, a non-disclosure that I've provided for you today. After I left the next day, I emailed the session, which comprises the body of elders in Presbyterian governance. I think there was at least 16 of them, letting them know of my meeting with the two pastors and making the two same requests to reach out to the victims of sexual assault and for the church to publicly repent of their use of non-disclosures. I know there was allegations that Tyson will likely bring forth that there was one of the victims of Bodie Wise at Eastminster was under NDA. Those are allegations. I haven't seen that, but it wasn't hard for me to believe since they were willing to give one of their very own pastors who did nothing to get fired except to try to keep them accountable for other issues that were going on in the church. And so I have attached that email and that letter that I wrote for you all to look at. And so just to conclude, children who are victims of sexual abuse and human trafficking have already been silenced. The reservoirs of shame that flood their souls keep them from crying out for help. The use of NDAs in those situations only exacerbate the constant state of shame and silence they have already had to endure. And this is evil because it keeps them from doing what I, a minister of the gospel, tell them to do, which is to cry out to the Savior for help. Tragically, we all heard what happened to Elizabeth's brother, Trey. And so my hope that is, if passed, House Bill 2688 would end the evil practice of using NDAs to silence minors who have had to endure the evil of sexual abuse. Furthermore, my hope is that these victims, that the temptation for them to alleviate themselves of the forced silence by way of suicide would also not be given any more strength for these institutions to use against them. They're precious little ones who bear the image of God who created them, and so may God have mercy on them. Thank you.
Okay, thank you. We now will have Dr. Karen Irene Countryman Rossworm via WebEx.
Thank you, and thank you
You
for
sure?
allowing.
Yeah, it's nice to see you. It's been a long time.
Yes, good afternoon, Chairwoman Humphreys and members of the committee. My name is Dr. Karen Irene Countryman Roseworm, and for 29 years, I have had the honor to walk alongside thousands of victims, survivors, thrivers of various forms of abuse and exploitation, providing direct services, developing effective research-based practices, and drafting and advocating for federal and state anti-trafficking legislation that is rooted in real life. However, amidst these roles and efforts, even I have not been free from abuse, and I have yet to find true safety, justice, and voice for myself. Thus, today I stand before you outside of my titles and roles simply as a Kansan, as a wife and as a mother who is asking you to help me and others, like Trey, for whom this proposed legislation is named, stay alive, survive, and thrive. He didn't have the chance. My life has been filled with a myriad of abuse on the continuum of violence as a child at home and in the church. After my mother died by suicide when I was 13, and as an orphaned adolescent, I was then groomed, abused, and exploited in federally and state-funded group and foster homes, and then on the streets, and later in publicly funded higher ed, where I should have been safe. In the interest of time, I ask that you refer to my testimony for more detail. I just want to respect everyone that's here. But what I want to make clear is this. When I consider all of my life experiences across a lifespan of abuse, it is not a one singular direct act by one singular perpetrator that caused me the most harm and that causes me the most harm and trauma. Rather, it is first the complicit behavior of those who were aware but did not exercise courage. And second, the institutionalized abuse, and consequently, the institutional betrayal that is empowered by policy and law, or the lack thereof. This includes the law, policies, and practices that promote and secure victim silencing through non-disclosure agreements, otherwise known as NDAs. Thus, worse still, by even sharing this testimony right now with you today, an effort I intend to just merely save my own life and continue assisting in the thriving of other victim survivors, I risk further harms to myself and my family today. With all of this, I am in support of House Bill 2688. This bill, as it is presented now, is just the beginning. This legislation in its current form serves only as a foundation for the law Kansans need to ensure victims' voices are no longer silenced by NDAs. If this legislation ultimately becomes the comprehensive law I believe it should be and that it will be, I and others could speak openly, free from the threat of legal retaliation, and more importantly, free from internal anguish. We, all Kansans deserve better. There is a groundswell of energy right now, and our efforts to expand and strengthen this legislation is possible. We as Kansans have the chance to be forerunners in this life-saving change, to come alongside Elizabeth and others across the nation to make this a reality. I look forward to working with this committee in the future to make this a reality right now in Kansas. I recognize and I humbly thank each and every one of you for your intentions and your efforts to make Kansas a safer place to live and thrive. Let's keep moving this forward. This is urgent. My life, our lives depend on getting this right. Thank you.
Okay, thank you. And people may have questions. If you can stay on with us, that would be great. Okay, Tyson Stewart, private citizen. Tyson, you're on WebEx. Are you there? Yep,
Yes.
okay.
Thank you, Madam Chair, members of the committee. I'm here today as a victim of childhood sexual assault. Some of you may know me from going public with my story of abuse that led to the discovery of at least 29 other victims by the same abuser. Chair Humphreys, Representative Lewis, it's good to speak with you again. I decided to go public because I knew one of the victims was unable to speak for themselves. They had reached a settlement agreement, and as a part of that agreement, he was silenced. When you're a survivor of sexual assault, your story, your experience is the only thing you really own in regard to that abuse. And to think of being a survivor and working through the trauma to come out healthy on the other end isn't hard enough. Imagine doing that with your proverbial tongue cut out. You don't get to own your story. Not to mention that organizations can litigate alternate realities within these contracts. This victim and his family told me that the organization under whose care the abuse took place, Eastminster Presbyterian Church, their claim that they still stand by, that the family requested the non-disclosure agreement, that assertion was, quote, bullshit. He did tell me that there is a clause in that agreement that should it be broken, they would have to pay Eastminster Presbyterian Church $36,000. Now, I haven't seen the document, but logic says, no way do you request a non-disclosure agreement for your son that was sexually abused as a minor and then put a financial penalty on him should he break it. The only thing that makes sense is that there is language in that document that legally created this false reality to protect Eastminster's image. When the point of contact for the organization and I first spoke prior to the investigation, he asked me, what do you want out of all of this? With a tone that was suggesting I was looking for money. And I responded with, how about getting the use of NDAs completely out of your church? I don't think Jesus ever preached about silencing victims. And he agreed with me. And yet here we are, almost a year after they released their findings, and they have yet to take such a measure. And the truth is, they never will. It is in their DNA, at least not until they are forced to by the passage of this bill. I urge you to help those survivors being silenced reclaim their experience. Protect future victims from living in a world where they have to decide between restitution and having a voice. You can help us all heal by passing this bill. And as a side note, Elizabeth, thank you so much for all of your work on this. I'm
Thank
grateful
you,
to be able to
Tyson.
join you in this cause, and I'll stay around for questions.
Okay, yep, thank you. Okay, we now will have Jill Butenbaugh, private citizen.
Hello, I'm Jill Butenbaugh, and I'm here to support this bill, and I concur with everything everyone before me has said. You have my testimony, so I would like to yield my minutes to Tracy Barclay.
Okay, thank you, Jill. Okay, Bruce, do you want to go first or Tracy first? Okay, that's fine. So Jill and Bruce have yielded their time to Tracy, so Tracy, come on up. Welcome to our committee. Thank you for being here.
Chairperson, members of the committee, thank you for this opportunity to speak today. I confess that I'm really nervous about being here speaking, not because I'm afraid to speak, but because I'm afraid of failing my daughter and failing the other victims and sexual abuse victims and trafficking victims. So this is the first time that we are publicly speaking about the abuse that 41-year-old Matthew McFerrin in Trinity Academy in Wichita, Kansas, perpetrated on my 16-year-old daughter. It has taken 5 years for my daughter to battle the demons that tell her every day that she should be ashamed, that it's her fault, that she's less than. But now she's starting to find her voice after 5 years. That voice would have been silenced had she signed an NDA. Her abuse did not stop when the physical abuse stopped. It follows her every day into her mental health, her sense of safety, and her future. While Trinity Academy continued to operate, she was left to carry lifelong consequences that she did not choose and could not consent to as a child. We as her parents are so proud of how far she has come. Every day she has to get up and battle what people have talked about already. We call it trauma brain at our house. It has changed her in ways that no child should have to endure. She's demonstrated incredible strength, resilience, and courage, but I would tell you, she's different. She is a different kid after going through this. She ranks in the 97th percentile for severe PTSD. She's not a normal college student. She's trying to get on with her life, but she won't go to basketball games and football games with her friends because the noise and being there impacts her nervous system. All we wanted was for Trinity Academy to say, we're so sorry that this happened to you, but now we are going to use this trauma for God's glory to protect other children. And this is why Trey's Law matters. This isn't just a Kanakuk issue. It's not an Eastminster Presbyterian issue. It's not just a Trinity Academy issue. This is a systemic abuse issue. So we want to talk about accountability. Sin's not meant to be covered. It's not meant to be hidden. It's meant to be brought into the light. Light is light, evil is evil. When abuse is hidden, it is not healed. It is protected. So after our child was abused, Trinity Academy sought a non-disclosure agreement. They wanted the harm that was perpetrated on her to be kept dark. She was offered millions of dollars. My daughter was. At 21 years old, she refused that money. She said, I'm going to choose truth over money. I'm going to choose light over silence. She wanted accountability. So at Trinity Academy had a town hall meeting when the abuse first came out. And on YouTube publicly for the whole state of Wichita or Kansas to see, he said, Pete Oakes, who's one of the founding fathers of Trinity Academy, said, Matthew McFerrin, he's not the enemy. He's a brother that stumbled. This statement was made about a man that groomed and preyed on my daughter for 10 months. There was no mention of a victim. And I don't mean by name, but I mean come alongside somebody that says, we have a predator in our midst. We need to come alongside and acknowledge this child's pain, get support for her, What they did offer her was an NDA. So like I said, true healing for a survivor cannot happen in the dark. Silence does not bring restoration, secrecy doesn't bring justice, and redefining abuse as a stumbling block while ignoring a victim is confusing, manipulative, and devastating, especially to a child that has been taught to trust pastors, teachers, and Christian leaders as moral authority. Pastors shouldn't want this, Christian teachers shouldn't, leaders of any institution should not want to excuse this behavior under an NDA. Trey's law draws a clear and necessary line. It affirms that abuse is abuse, that victims have the right to speak, that no institution, religious or otherwise, should be allowed to silence survivors, excuse criminal behavior, or redefine harm to protect itself. This 16-year-old survivor from Trinity deserves protection. She deserves adults that name evil for what it is. She deserves a law that would stand firmly on her side. Future children deserve the same protection. I urge you to pass Trey's law and send a clear message that Kansas will not tolerate the concealment of abuse, the silencing of victims, or the misuse of authority in any institution. Thank you for your time.
Okay, thank you, Tracy. We appreciate that. So committee, that's our in-person proponents. We're going to go ahead and have questions for them. And I might start. So Tracy, could I ask you a question? So just so that I understand, I know your daughter was maybe 21 when she was offered the NDA, but what if she was 16? I mean, how does that work if it's a minor? Like what was your story, or how does that happen if they're less than 18?
Thank you for asking. Our story, she was 15 when the grooming started, 16 when the abuse happened. She lived in our basement for 2 years because she was so ashamed. She didn't want people to know, cut everybody off, cut all of our friends off. Anybody that we spoke to could not address our daughter because she was so ashamed. So for us, we were not offered the NDA until the civil suit came about because she wanted to be able to keep her voice, and that was not going to be allowed to happen otherwise.
So she was already an adult.
So she was an adult, but
Okay.
we took the time to have her get healing, and the reason it has taken so long was so that she could get enough counseling and be in a place where she could go through the process of getting accountability for herself.
Okay, thank you. Committee, what questions do you have? Representative Sappington.
Thank you, Madam Chair, and this is for you as well, Tracy. So what happened with your daughter's abuser? Were there criminal charges ever filed, or did it run out the statute?
Yep, there were criminal charges filed, and he got the maximum sentence, which was not long enough. It was 34 months.
Thank you.
Representative Osman.
Thank you, Madam Chair. I suppose I have a question, but it's not directed to anybody, but I'm happy to have you address it if you'd like. So first of all, to all the proponents, thank you very much for your testimony, and thank you very much for your powerful stories. I am in support of this bill, but I do have a question. The reason that you have an NDA is obviously, in this particular situation, is to hide the truth. But the NDA itself comes about because of a settlement. And the settlement happens for a variety of reasons, whether it's because you don't wish to, there's the uncertainty of the trial, or the cost of the trial, or the length of the trial. And all of that gets settled in a settlement. If the NDA is taken up, how does that affect one's ability to, how does that affect the victims who may not wish to go through a trial, but now the organization that is perpetrating these crimes has less incentive to work out a compromise or work out something to help the victims?
That's a good question. I feel like for us, there is a way that you can protect victims and not have an NDA. And for us, it would be coming alongside them. It costs money to be a sexual assault victim. I hate to say it, but it does. There are years of therapy, twice a week, I mean, it's been 5 years for us, and it's probably going to be forever to go. And it costs hundreds of thousands of dollars to have a civil suit. So I feel like this isn't just about bringing alongside people. They need to make the right decision to do the right thing because it's the right thing to do. I feel like it deters people from becoming sexual predators in institutions because they know they're not going to be protected.
Does anyone else would like to answer that question too, maybe from a different standpoint? I don't know, just offering that. Okay, great.
If I could,
Please go ahead.
and I know this is like a quick, not thorough answer of your question, but I really appreciate your question. And I just wanted to highlight that when I mentioned that there's systems in place that encourages the NDAs and specifically like pays for silencing, this comes about for a variety of reasons. In my situation, again, we got to look at things like the reality that if abuse happens in a publicly funded organization or entity, the state has limitless caps to pay for the protections of the perpetrator. That then fueled with the reality that in civil suits, there's these caps. If you're a victim, I mean, it barely pays the attorney fees. So the attorney that should be representing you if you're a victim is also encouraging you to sign that NDA. So I hope that is at least starting to answer some of your question, that there's a lot of dynamics, but I do understand where you were going with your question as well. So thank you.
It does. Thank you so much.
Sorry, Ms. Phillips, did you have your hand raised too?
If I may respond to the question, I think what you are alluding to is, does this have a chilling effect on settlements occurring or maybe depressing settlement values even? It's my 5th time this week testifying on this in different states across the country. And that's one of our frequently asked questions. And the answer, based on empirical and anecdotal data, is no. This does not decrease the settlement value, and it does not chill the effect or push things to trial that would otherwise settle. So we have a section on our website that goes into more detail on those studies. Since this has been passed in a broader Crime Victims Act in California in 2016, in Tennessee in 2019, and as I mentioned, several other states since then, we can actually look at that and answer your question emphatically, that does not occur.
Thank you very much. Actually, my alternate question exactly was what happens in other states. So thank you for addressing that.
Yes, sir.
Okay, we have a question from Representative Carmichael and then Barrett.
Thank you, Madam Chair. This is excellent legislation, long overdue. And I can tell you from a lot of personal experience representing people in these contexts, if you take NDAs off the table as a matter of law, then it's not a part of the negotiation. And as a result, people still get their full value of the settlement because the employers typically know that their NDA isn't worth the paper it's written on. Now, my question, Ms. Robb, are you still available? Oh, I'm sorry.
Sorry, I think yep, I'm available. Yep.
Yeah.
Oh, there she is. Okay. Thank you, Ms. Robb. I was looking at this legislation. I don't know if you have it in front of you, but at line 9, it limits, as far as I can tell, the abrogation of non-disclosure agreements to individuals who are a party in an action. I'm not sure whether this means in the same action, but more broadly, in my experience, oftentimes these folks go from employer to employer. They do things at one employer, a settlement may be reached, an NDA that shuts up the mouths of the victims, then they go somewhere else. And when the lawsuit is filed, it's against the employer, not the assailant, oftentimes. And then when you go to try to get discovery to show a pattern or a practice and eventually establish the current employer should have known, you're met with an NDA so that the people who want to try to help others are not handcuffed, but their mouth is taped shut. Does this reach far enough? Is there something we can do to help vitiate other NDAs, not necessarily involving the present party?
There certainly is. We could certainly add stronger language to this particular bill, and I did just pull it up, by the way. And I think the argument is a very sound public policy argument that when you're silencing a victim, you are essentially taking away credible witnesses to speak. So I believe, Elizabeth, I'm not sure if you want to touch on that in the Texas piece of legislation as well, because I do believe that was addressed there.
Yes, the bill that's gone the furthest to include other parties, such as the ones you're referring to, is the Texas version that was passed and went into effect last September. It does include employees who may be witnesses to the underlying cause or claim. So I would encourage the committee to look at the Texas legislation, and if I were there in person, I would provide the materials, but it's all on tradeslaw.org as well for your convenience, if that's helpful.
Representative Barrett.
Thank you, Madam Chair. Elizabeth actually just answered my question with her last statement, which was the website that everyone can go to for more information. So I appreciate everyone's powerful testimony today.
Okay, thank you. Committee, any other members have questions? Anybody? Okay, seeing none, I do want to draw your attention to many written-only proponents, Gina Meyer Hummel, who most of you know, I think, Tammy Sanders, Tiffany Reese, Lisa Ritchie, Laura McGrew, Julie Shaw, James Jost, Lynn Hankins, Janie Buchanan, Jill Greer, Kim Borchers, Maddie Ritchie, Jeff and Denise Bennett, Diana Matthews, and Roger Matthews, and Shelley Packard, as well as our three proponents who were going to be speaking but yielded their time, Ashley Marquez, Jill Butenbaugh, and Bruce Barclay. Okay, so please look at that over. I do anticipate working this bill on Monday. So I'd like to go ahead and get that passed out of the committee and onto the House floor. So with that, I'll close the hearing on House Bill 2688. And thank you all for coming. We really appreciate you and telling us your stories, and we will take action on Monday. Okay, so the hearing is closed on House Bill 2688. Committee, I now would like to work some bills if we can get that done. I think we can. Let's first look at let's go ahead and do 2747. And Jason will give us a little reminder. We actually just heard it yesterday.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. Again, House Bill 2747 from yesterday is the one about the sentencing statute in the criminal code and requiring the court to consider certain factors when determining whether prior DUI-related crimes will be counted for purposes of enhancing your sentence as part of your criminal history and treating them as felonies.
Okay, thank you. Any questions for Jason? Okay, do we have any amendments on this bill? Representative Osman.
Thank you, Madam Chair. I have two amendments, so we can start with either.
While they're passing it out, would you like to explain your amendment, Representative?
Yes, thank you, Madam Chair. This effectively just, the bill itself, I really like, but I think we can do more. And I think that we can, this particular one changes the classification of driving under the influence from a non-person to a person crime which would change as well some of the penalties involved.
Okay, committee, what questions? I mean, take a look. We can take a minute to look at it. If you have any questions for either Jason or the bringer of the amendment. Representative Vaughn.
Thank you, Madam Chair. Thank you, Ranking Member, for bringing this. Can you just give more background on why you're bringing it and, yeah.
Sorry. So attached, I'm looking at it. The revisor actually did attach. This is from House Bill 2498 that was introduced into committee. But because of the total number of bills that we have, we couldn't get to everything. So we're looking to add in, this is a bill that was introduced earlier. So you can look at 2498, which is the predication as to why this was brought in as an amendment. And it comes to us from Mothers Against Drunk Drivers, if that's of significance to you.
Okay, just taking a look at it. Committee, any other questions? Okay.
If I'm not fully describing it, I mean, I'm happy to have the revisor to beef up my explanation.
Okay, go ahead, Jason.
Madam Chair, the very quick technical explanation is you won't see the changes very much in the underlying bill because they're very small. In commercial DUI, the word person is changed to non-person when describing the felony, and the same in the DUI statute. They're both very long statutes, but anytime it says it's a severity level X person, non-person felony, it becomes a person felony. That's the only change in those two sections that would be pulled in. So, and then for the broader purpose, right, your criminal history, now you have a person felony in your record instead of a non-person felony. You remember that moves you across the grid faster. So it would be a similar enhancement of your criminal history if this was enacted.
Representative Vaughn.
Thank you. Jason, so to confirm, since this is criminal law, it would not be retroactive, correct?
Madam Chair, that's correct. So these penalties would only be imposed if you're convicted of that section, you know, the section that was in place at the time of your offense is what applies to you. So if you're convicted for DUI before now, the new DUI law wouldn't apply to you unless you're convicted of it after whenever this one takes effect. So.
Yep, looks like statute book. Representative Osmond. Oh, sorry. Representative Carmichael.
Question for the revisor, and I apologize. I'm very surprised by this attempted amendment. It may be a very good one, by the way, but I don't know. But is it limited to commercial DUI that now turns every DUI into a person crime? I'm not following. Can you help me, please?
Thank you, Madam Chair. So it's both commercial and regular non-commercial DUI. And the title of 2498 kind of says it pretty succinctly. Classifying crimes related to driving under the influence and driving a commercial vehicle under the influence as person crimes. That's all the bill does. Moves them from non-person crimes to person crimes.
If I might further inquire, standard DUI, as bad as it is a misdemeanor. And so does this somehow make it a person misdemeanor?
Yes.
Okay. I want to discuss this at the appropriate time, Madam Chair.
Okay. Any other questions, first of all? Okay, now we'll go ahead and do discussion. Representative Carmichael.
I'm 100% behind House Bill 2747. I'm very disappointed that the maker of this amendment didn't share this idea with me so that I could be properly prepared. This is potentially a bad bundle because we haven't had a hearing on the maker's bill, HB 2498. We haven't heard witnesses pro and con. We haven't heard what the potential or possible ramifications of this could be. And before we make an important change like this, even though it's just a few words, even before we make this kind of an important change in our DUI laws, we need to have a hearing. And so as much as I want to vote for 2747, I'm not going to be able to vote for a bad bundle like this. I'm very disappointed. Thank you, Madam Chair.
if the amendment gets on. Yeah.
Yes, I presume the amendment would get on. I'm sorry. Thank you.
Uh-huh. Any other comments or discussion about the amendment? I'll discuss. I agree with the former representative. I think this could be really good, but I would like to keep HB 2747 clean as far as this goes. So, but any other discussion by the committee? Representative Barrett.
Thank you, Madam Chair. Originally, and I actually had told the representative that I would support this, but I guess this is bringing up some pretty big concerns that we probably should have a hearing on it. There are some pretty big changes. I guess I didn't really consider that just in the heat of the moment. So I don't think now. I think it's a good idea. We probably better have a hearing on it.
Thank you. Any other comments? Okay. Would you like to move your amendment?
For the purposes of voting, yes, I will. I will move my amendment.
Okay. Do we have a second? Okay. I don't think we have a second.
All right. Thank you.
Okay. So committee, that amendment is, we are not going to vote on that one. We didn't for lack of a second. Do we have any other amendments?
There was another amendment for the purposes, just as a reference, it's 2499. However, I am not going to be moving that amendment today.
Okay, thank you. How about any other amendments? Anything else? Okay, seeing none, then we will go ahead with the underlying bill, House Bill 2747. Do we have a motion on that?
Thank you, Madam Chair. I move that we pass House Bill 2747 favorably for passage.
We have a second. Representative Ward seconds. Okay, discussion on House Bill 2747. Okay, seeing none, would you like to close on your amendment? Your motion?
Yes, thank you, Madam Chair. I move and close my motion.
Okay, committee, you've heard the motion to pass House Bill 2747 favorably for passage. All those in favor say aye. Opposed, no. Okay, that is unanimously passed favorably. House Bill 2747. Okay, thank you, committee. We now are going to look at House Bill 2521. Okay, House Bill 2521. And Jason will give us just a little reminder what that's about.
Madam Chair, very simply, this is the bill that adds child placement agencies that contract with the Secretary for Children and Families into the Kansas Tort Claims Act.
Okay, and I believe we have amendments. I'm not sure who's offering it. I'll offer it, but do we have are you offering it? Okay, Representative Bohai is offering an amendment for House Bill 2521. Okay, would you like to explain it, Representative, or would you like the reviser to give us fill us in on this?
Thank you, Madam Chair. Could we start with the reviser?
Sure. Jason?
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. So you might recall during some discussion earlier on the bill, I at least had a couple of concerns, including child placement agency and the definition of state made that agency synonymous with the state for purposes of the Tort Claim Act and made it unclear whether the state would be liable or the agency would be liable. And we had some discussions with multiple folks and realized it may have just been misplaced in the definition section. Moving that same language down into the definition of governmental entity would then allow, wherever that term is used in the act, it clearly says governmental entity would be the state or a municipality, or it's one of these agencies. And so everywhere in the act subsequent to that it says governmental entity, you would just be able to put in the words child placement agency and get all of the same protections, remedies, liability, et cetera, that they were seeking. So we think this gets to exactly what they wanted, just in a better way. And the secondary issue was the original language talked about placement, the placement agency having a current contract with the secretary, but claims are based on a time frame. So it made a little more sense potentially to have it linked to a contract at the time that the act or omission giving rise to the claim occurred. So just think of a tort claim, right? If it arose in 2024, that's the relevant time about whether they were covered by the Tort Claims Act or not, whether they had a current contract or not 2025 when they may not have a contract. So this attempts to address both issues by the definition and the time frame.
Okay, thank you. Representative Bohai, did you want to speak to the amendment?
Thank you, Madam Chair. Yes, so it's my understanding now that it would not be that the agency would be the one, if there was a claim, that would pay the claim. The state is not the one that is responsible. Is that
Yep.
clear-ish?
Madam Chair, Jason Thompson again. Yeah, and I kind of didn't get into that part. I talked too long about the other stuff. The way the Tort Claims Act works is when you sue the governmental entity, that is the entity responsible. So, for example, you sue the school board is responsible. If you sue the child placement agency, they'll be responsible. It's much clearer this way, that it rests with the entity and not the state.
Thank you, Madam Chair. And I believe that was the original intent
Mhm.
when they were trying to bring it. And so anyway, thank you to the revisers for working
I
on
think
this.
we have yeah, this is good. Representative Carmichael, question or comment? Go ahead.
Thank you, Madam Chair, and I will try to confine my remarks to the amendment. I do appreciate that this is an important improvement in this legislation. It takes the taxpayer off the hook. But we just heard from Dr. Karen Irene Countryman Roseworm in 2688, and what she talked to us about was caps under things like Tort Claims Acts. And even though this amendment makes some change about who picks up the tab, it doesn't change the fact that recovery under the Kansas Tort Claims Act, absent additional insurance coverage, is limited to $500,000. Do we want to limit these claims to $500,000? Is that helpful to children? Or is it helpful to insurance carriers for the agency? So even though this amendment improves the bill, I think I'll vote for the amendment, but it doesn't fix, in my judgment, the biggest problem with the bill. And I hope I'm wrong. Maybe somebody could, because there is a provision that if a governmental entity purchases insurance in excess of the $500,000, then the cap is whatever the amount of insurance that was purchased is. But there's no guarantee that these entities will purchase anything more. And I think this limits the victims of sexual assault's ability to recover their full measure of damages, and I can't stand for that.
Representative Lewis, are you speaking to the amendment or to the bill, would you say?
More to the bill, probably.
Okay, why don't
I
we
was
go
gonna- I
ahead,
was
and I
gonna re-
think Representative
gonna
Carmichael
respond.
pretty much spoke to the bill, but let's go ahead and speak to the amendment first and then vote that in or out, and then we'll talk about the bill. Okay, anyone else on the amendment? Okay, seeing none, would you like to move your amendment?
Madam Chair, I move my amendment.
Do we have a second? Representative Barrett seconds. Any other discussion on the amendment? Okay, seeing none, you may close.
I encourage your support on the amendment. Thank you. I close.
Okay, you've heard the amendment to House Bill 2521. All those in favor say aye. Opposed, no. Okay, so the amendment gets on the bill unanimously. And now we will have discussion on the bill. Representative Lewis.
Thank you, Madam Chair. I appreciate the concerns that my colleague from Wichita has expressed, and I think they're legitimate. But I think we do have a solution already in the law that we might have overlooked, he might have overlooked. When we passed legislation in 2023, I believe, which extended the statute of limitations for child sex abuse from age 21 to age 31 of the victim. As part of that legislation, we also removed Kansas Tort Claims Act immunity from municipalities and others that were might be the defendants in those cases. I believe that that would apply here, though I'd ask the revisor to check me on that. So the point being that the child placement agencies would be entitled to Kansas Tort Claims Act protections, except to the extent that the claim was based on sexual abuse.
Jason, do you have any comment about that?
Sure. Thank you, Madam Chair. Yes, I had the opportunity to get very well acquainted with the Tort Claims Act again, since the last time we dealt with this was 2023, and the bill that you were just referencing, Representative. In 2023, in KSA 75-6104, which deals with the exceptions to liability, the legislature passed that the large exceptions to liability in that statute do not apply to claims arising from a childhood sexual abuse claim under 60-523, the one that includes all of the offenses that you can bring up until many years after your 18th birthday. In addition, in 75-6105, the maximum liability for claims, which is, as the other representative was saying, $500,000 or the insurance amount, correct? You added an additional provision that says this section shall not apply to any claim for recovery of damages against a governmental entity arising from childhood sexual abuse as defined in KSA 60-523. So the cap that would normally apply does not apply to childhood sexual abuse cases, and that's for any governmental entity. The legislature just did that in 2023.
Okay, thank you. Any other comments? Representative Vaughn.
I mean, that is an improvement in my understanding of the bill, but I mean, there are still other horrendous forms of abuse and neglect, and that would be subject to the tort claims and the $500,000 limitation that would be imposed under this bill for seeking restitution for those crimes. And I guess when I think about this, like it's a catch-22 because I want, like, the state made this decision in a sense, like they have created this problem where we have privatized, and now it's difficult for these agencies to get insurance, and they should be insured. Of course, they have to be in order to operate. But I go back to the question of the opponent, which is why are the premiums for these insurance companies going up? And I don't know if it's because it's a monopoly on the market. I don't think that's the reason why. I think it's because of these types of cases and knowing that there is a significant level of risk. And I think if we change the law and put this under the Tort Claims Act, I think the loser is the child. And while I sympathize with the proponents and I see it as a catch-22, I don't think that I can support this bill for that reason.
Thank you. Representative Carmichael.
I was commenting to Mr. Thompson earlier this afternoon that I'm a generalist also, and that the law changes sometimes, and I don't keep up to date with all of the changes that have occurred. And I didn't remember that we had exempted these claims, or the limitation from the Tort Claims Act. So as I understand what the revisor and Representative Lewis are telling me is, by enacting this law, we don't impose any cap on the amount of recoverable damages. And I think I'd like to ask that as a question of the revisor to make sure that that is the revisor's opinion, at least.
Jason.
Madam Chair, the language in 75-6105, say the right number, 75-6105 subsection D is specific to claims arising from childhood sexual abuse. So to the other representative's point, it would the cap would still be applicable to claims for other harms or torts, but not childhood sexual abuse.
Meaning things like slips and falls, those sort of things in these facilities.
For example, yes, anything that was not sexual abuse.
Then, Madam Chair, let me address this from the standpoint, then what are we accomplishing here? The insurance carriers come in and they say that they're just being beaten up by sexual assault claims that are old claims or events that happened maybe years before. These are typically claims-made policies. And that in essence, by us expanding the statute of limitations, that we've exposed them to a lot more liability, hence their premiums have to go up. And what they were asking for was a limitation on liability. And I don't think at this point, and by the way, I've heard those pleas from insurance carriers for as long as I've been a lawyer, even when I represented them. And when there are crises of availability of insurance coverage in important areas like this, the prime example being the medical profession, the state has taken some serious actions to establish funds and so on. But as was observed by someone at our hearing, most people would tell you the biggest driver of insurance claims, or excuse me, insurance premiums is not claims experience, it's returns in the bond market and the stock market. Because they take the premium dollar, they invest it, they make money, and then they pay the claim 5 years later after it's come to fruition. So I don't know why we're doing this at this point. Hopefully somebody else can tell me. I know we're imposing additional hoops on a plaintiff because the Tort Claims Act comes with notice provisions. You make notice, you wait for them to deny the claim, then once they've denied the claim, then you go ahead and file your lawsuit, or the lawyer makes a mistake and doesn't realize he or she has to file a notice of claim before they file the lawsuit, and they file their lawsuit and then they find they've blown the statute of limitations. That doesn't help a victim either. So why are we doing this? And I certainly invite input from anyone to help me understand what's the advantage now. How does it not hurt the victim and yet protect the facility?
Representative Bohai.
Thank you, Madam Chair. I probably won't be as eloquent as my colleague. I definitely will not be as long-winded. That was his side comment to me. My view is this: in my time here in the legislature and in the different opportunities I've had, whether it's be on this committee or subbing on the Child Welfare Oversight Committee, I have come to learn that when legislation takes time, there's typically a reason, but at the same time, and it's my understanding that this isn't the first time that they've tried to work through this. When we said as a state we are privatizing this, and we overlooked what was going to happen, and we're now trusting these private companies, I don't feel like if we don't do this, there's other things I want to keep these private companies accountable for, and I can't go after them if their costs keep going up because of their insurance. So I'm sorry, there are issues that I have with some of these things, and I would like this little thing to be, I know it's not little, but I would like this mitigating factor to be taken care of so that that comes down on their priority list. They can focus on what they're supposed to be focusing on, and we can continue to try to help the children of Kansas.
Okay, thank you. Any other discussion? Representative Lewis.
Thank you, Madam Chair. So wanted to address Representative Wichita's comments. We did extend the statute of limitations from age 21, 3 years after majority, to 31. But the research shows that most people don't disclose sexual child abuse until they're in their 40s. So as a practical matter, although it made us feel good, I don't think it actually extended or expanded exposure from, for instance, largely institutions who are responsible for the child sex abuse. So I don't think that law that we passed has had a big effect. Certainly, I haven't seen that result in Kansas in the last 3 years, where you have a slew of lawsuits being brought by victims of child sex abuse. With respect to, on the one hand, we're giving them protection if it's not sex abuse, and on the other hand, we're not. Yeah, it's a compromise. This isn't going to give them these agencies full protection under the Kansas Tort Claims Act, but it'll give them some. So we're giving them some relief, not complete relief. And I think that's a good compromise, and I support the bill.
Okay, thank you. Any other discussion? Representative Barrett.
Thank you, Madam Chair. And yeah, just kind of to echo that, as well as what Representative Schreiber had said last week, it just makes sense to me that whether you like it or not, the state contracted out these services. And so this is a duty that was done by the state. Now it's contracted out. It's expanding the coverage that goes to mental health, that goes to all the other state agencies. Personally, I'd like to see another bill in the future that raises the cap. I'd be for that, because I don't think it's been updated forever to apply to all agencies. But I think this is just keeping it standard. So that's why I'm going to support it.
Okay, thank you. Anyone else to speak to the bill? Representative Osmond.
Thank you, Madam Chair. I agree with Representative Carmichael and the question of what is going on with this bill. It can be one of two things. Either the $500,000 cap applies to sexual abuse, in which case we are limiting victims' ability to seek and maintain compensation, or it doesn't apply. And the revisor seems to indicate that it doesn't apply, in which case the entire reason for this bill goes out the window, because that's the whole reason that they were coming to us in the first place. And I'll note that the proponents of this bill, their chief complaint was insurance premiums are going up. I understand that. I feel for them. 100% increase year over year over year. Absolutely unsustainable. Like, I get it. But the proponents of this bill did not say that the claims were outlandish, or that the compensation the amount of money that they received was outlandish, or that the claims were spurious. There was no argument to that fact, just that their insurance premiums were going up, and we need to help solve that. I'd like to help solve that. I don't see that this is the way to do that, because it is going to re-victimize victims, which is not what we want to do.
Okay, seeing no more discussion, do we have a motion on the bill?
Thank you, Madam Chair. I move that we pass House Bill 2521 as amended favorably for passage.
Okay, any other discussion? Representative Bohai. Oh, you're seconding. Okay, seconding. Any other discussion? Okay, seeing none, would you like to close?
Thank you, Madam Chair. I close and move my motion.
Okay, committee, you've heard House Bill 2521, motion to pass it favorably as amended. All those in favor say aye. Opposed, no. The ayes have it. And I think my colleague, Representative Carmichael, would like his no vote recorded. And that's it. Okay, so we have passed House Bill 2521 favorably for passage as amended. Okay, let's take a look at House Bill 2460. Yes. Okay, so that bill, we already passed it out of the House, and I passed it out of the committee onto the floor of the House, and then something came up that it seemed like it needed to be amended, and it just seemed the easiest to amend it within this committee. So I didn't bring mine. So Danica, is that yours? No, it's yours, Jason's. Okay. 2460. Thanks. Okay. Do we have amendments? Yes, we do. That's why it came back. I will explain the amendment, I think, as if it's when I'm thinking. There was a discussion, especially in calendar with caucus, the Republican caucus, that maybe we should include the household rather than just the legislators or others, but include anyone who is residing at that address. And the concern was people who are up here and their wives are back in the district at home, and it's very easy to find out what their address is. And so it's just, it's adding this section, as you will see, it's on page 8. It's really the third page of the amendment. Any person who resides at an address that is subject to restriction from public access pursuant to subparagraph A, little I or little 1 or 2. So I don't know. Jason, would you like to explain anything different than what I said?
No, Madam Chair, I would just say that the way you amended the bill, you added 2 subgroups to the ability to remove from the public access. Basically the current law folks, plus the 5 years of employment provision, and then the new group of elected officials. And this new provision would be any person residing at the household of any of those 2 groups.
Okay, any questions or discussion on the amendment? Representative Schreiber, then Osmond.
Thank you, Madam Chair, and this be for Jason. I think it's because of the Diet Coke I'm drinking, but resides, is that defined somewhere? I'm thinking if someone has a second home somewhere and they reside there for a few weeks or whatever, would you not disclose or not allow not disclosing that address as well? And I'll stop drinking my Coke.
Madam Chair, Representative, so since we're in an open records exception, I'm not as concerned about the specificity of the word, but resides does have a particular meaning. So I'm just approaching it from a practical standpoint. The person would have to say, I reside at this address, and this covered person owns or is a home, that's their home address, or they own that home. And so I'm asking for that to be hidden so that it's harder to find that person. That's the process you would have to do to use this. So because you're linked to a protected person, for lack of a better word, you would have to say, I reside at this address, and this address is subject to restriction because of this person's home ownership or this person living in that home.
So you could restrict 2 addresses for the same person?
In theory, yes. So if I'll just use, if the chairperson owns a property and the chairperson resides at a different property, people at both of those places could want to restrict that information so that you can't find out either of those places that the chair is connected to, just as an example.
Representative Osmond.
Thank you, Madam Chair. So just point of clarification, because it only mentions a person who resides in an address one time. So to clarify, this is for both any elected official and capers and retired people, or people that have served within 5 years of capers, or, yes.
Madam Chair, it would apply to both categories of people. The elected officials in A(2) and all the folks in A(1), which are all the current folks, police officers, municipal judges, attorney generals folks, plus the amendment you made, persons who were employed in those positions for 5 or more years, rather than the retirement, which we got rid of. You got rid of.
Representative Carmichael.
Thank you, Madam Chair. I won't belabor this, but for our revisor, I live and I reside, my domicile is in Wichita, Kansas. I have an apartment up here in Topeka, Kansas, where I'm probably at far greater risk, quite honestly. Is there anything I can do to protect public filings about an apartment, especially if I happen to be the owner like some of our members are?
Jason.
Madam Chair, you just have to go back to the current law, which is not changed by this. It's at the bottom of page 7, beginning in line 36. These are records searchable by keyword that identify the home address or home ownership. So it's about your home address or your home ownership. I don't know that it would cover a rental. You could try with the Shawnee County folks and maybe they would allow it, but it's focused on ownership and home addresses.
Amazing. The comment is, my constituents can find my apartment in Topeka, but they can't find my house in Wichita. Thank you, Madam Chair.
Okay, so we're on the amendment. Does anyone have any more discussion or questions on the amendment? Representative Curtis.
Thank you, Madam Chair. And as you might recall, I was opposed to this in the beginning. I'm still opposed to it as we are adding more people. Can I please add my bus driver, my mailman, because they are at far greater risk than I am.
Okay, anyone else? I will move the amendment. Then do we have a second? Representative Williams seconds. Any last discussion about the amendment? Okay, seeing none, I'll close. And committee, you've heard how the amendment for House Bill 2460, all those in favor say aye. Aye. Opposed, no. The amendment passes, and it is now put on House Bill 2460. And we now have to pass that out of the House again. Representative Lewis.
That was my point of order question is, do we need to now pass it out as amended? I guess we do.
Yes, we do, because it got returned to the committee, so now we have to pass it back out of the committee. Okay, we've already had a little bit of discussion about the bill. I'm going to go ahead and ask for a motion on the bill.
Thank you, Madam Chair. I move that we pass House Bill 2460 as amended favorably for passage.
Okay, any discussion? Oh, second on that. Representative Sappington seconds. Any more discussion on the bill? Okay, seeing none, would you like to close?
Thank you, Madam Chair. I close and move my motion.
Committee, you've heard the motion to pass House Bill 2460 favorably for passage as amended. All those in favor say aye. Opposed, no. Okay, the ayes do have it. Representative Carmichael would like his no vote recorded. Nobody else. Okay, so that's another one that we have repassed out to the House. Okay, I would like to do a couple more. Let's look at House Bill 2512. It was about sentencing. House Bill 2512. Sorry, it's 2612. That's my fault. And you pointed that out to me earlier. Sorry, you all, it's 2612. Okay, Jason, could you give us a little update on 2612?
Thank you, Madam Chair. So this is the bill that amends the statute about sentencing in multiple conviction cases, and it's focused on multiple convictions where the non-prison sentence is imposed. And so the non-prison term under current law is set for each crime, and you serve each of those sort of individually. And the bill would change that so that the non-prison sentence would, the supervision term would be set at the maximum for the longest supervision term imposed for any of the crimes. And that would be the single supervision term for all of the crimes. And the example given was under current law, you might have a 12-month, an 18-month, and a 24-month all in the same case. And in that case, under this bill, they would all be 24 months. So you just set one instead of individual ones. That's the best I can do.
Okay, thank you. Questions on the amendment? Or wait, sorry, on the bill? No. Okay, first of all, are there any amendments? Representative Barrett.
Madam Chair, I've had so many amendments. I can't remember if this is the one that Kearney and Associates asked for. Jason, was this the bill I had the Kearney and Associates amendment for? No? Okay, thank you. No, ma'am.
Okay, no amendments from Representative Barrett. Any amendments from anyone else? Okay. Yes, we'll go ahead and have a motion.
Thank you, Madam Chair. I move that we pass House Bill 2612 favorably for passage.
We have a second. Representative Barrett, seconds. Representative Vaughn, did you have a discussion?
Yeah, I think I'll maybe start with a question for Jason if I can. 'Cause
Okay.
I don't know if other people like really sat down with this bill to kind of think through what the implications would be. Because I was doing that and I think there are a lot of potential consequences to this. And so I just want to ask a question so that I think the thought process I went through that maybe we can, that what I'm thinking is correct. So essentially, we talk about how one probation term would be selected. But I think the point that was being highlighted in the opponent testimony is, for example, if someone has 2 sentences and they completed their probation term, or what is the equivalent of completing that sentence prior to what word am I looking for? Not complying with their probation. And so then they are subject to the underlying prison sentence, which as it currently works would only be the remaining sentence. So the probationer has completed their 1 sentence for the probation they have completed, and as the system currently works, they would only have to complete the prison sentence associated with the other sentence. But if this bill passes, then the probationer would have to complete the combined prison sentence on top of having to complete their probation. So I don't think this is just a clean, let's make one probationary sentence to make it easier on folks. I think this like fundamentally changes sentencing guidelines. And I just want to make sure we all are on the same page and that I'm understanding that correctly.
Jason?
Madam Chair, I don't think I heard anything in there that was incorrect. I think it would change it so that, you know, for example, now you might have a 12, 18, and 24 month on 3 different things, and all of them would be the same under the new law. So I think the example given in the testimony was right now, once you get past 12 months, that one falls away. So if you violate and you're revoked, you only have the other 2. Under the new one, if you all of them are 24, then all of a sudden you've still got all 3 active, and you would have to serve all 3 of those. I think that's accurate, and I think that's the policy choice you're being asked to make. I think that's all accounted for in what I heard.
So Madam Chair, if I may, so I mean, my general thoughts on this are, I wish we would have heard more testimony on both sides, because I think this is a substantial change that will impact the criminal justice system. But I guess my general consensus was that based on that information, I do not feel compelled by the proponent testimony, who my main takeaway from that is it's complicated to keep track of multiple probation sentences. One probation sentence would make it easier to do our jobs, but I think that is at the cost of the rights of the justice and the rights of the probationer, the way that the system currently works. So I guess I just generally wanted to make that point and say because of that, I am not in favor of this bill. I think the other point I wanted to make was about caps. So right now under the law, I have my notes. Thank you everyone for your patience. So essentially on page 3 of the bill, where it says, and the supervision duration set forth in KSA, et cetera, shall not apply. That is eliminating probation caps for multiple convictions as they are under existing law. So while probation caps will continue to exist for single convictions, they will now no longer exist for multiple convictions, which I think is another significant change to the criminal justice system. So those were 2 key points I wanted to make. I think it's a bigger debate, so that's why I will be opposed to the bill. Thank you.
Representative Bohai?
in a strange moment of agreement with my colleague from Johnson County. I also will be a no on this as it currently stands. I don't think it's ready.
Okay, what other discussion do we have or questions on the bill? Anyone else? Okay, so I getting the feeling I would like a little more discussion, because if we think it's not quite ready, I might ask the maker of the motion to withdraw the motion. But I kind of would like a little bit of discussion here to see where the committee is on this. Representative Lewis.
I agree that this is a big jump and we may not have had enough time to think through. And so I think it would be better to wait and think about it some more. I do think we need to make some changes to the current law, but I'm not sure that we've gotten it right with this one.
Okay, thank you. So with the permission of the second, the maker of the motion.
Thank you, Madam Chair. I withdraw my motion.
Okay, thank you. Okay, committee, we will not be working House Bill 2612 today. Okay, now we're going to go to House Bill 2537. Is there one or the other? Do I have my numbers wrong? I don't want that one. Not that one. What is 6? 2537. I thought that's what I said, but okay. 2537. Committee, I so appreciate you all. We have a lot of work to do and everyone's working together and I really do appreciate it. Okay, 2537. Jason, you want to remind us about this one?
Thank you, Madam Chair. This is the bill about sexual extortion, or sextortion, as everyone was calling it. It has a new provision where the Attorney General would develop some materials that would be used to educate the public about this crime. It increases the penalties for the crime of sexual extortion when the offender is over 18 and the victim is less than 18 or is a dependent adult. And it creates additional crimes within extortion, sexual extortion of aggravated, causing great bodily harm, and aggravated, causing death.
Okay, do we have any amendments on this bill? Yes, we do.
We do, and if I might, Madam Chair.
Representative Lewis.
So there is this is an amendment, but I was approached by the chair of education today, a few hours ago, and there's an educational component to this bill, which I think is very important. But she persuaded me that her education, they also have a bill that concerns educating K through 12 about sextortion. And so I didn't get to the revisor sufficiently to have another amendment drawn up which would excise that. So I don't know how the committee, the chair, wants to proceed. In addition to this amendment, which I would put forth, that would be another amendment I would want to have in the bill before we pass it out. I suppose that could all be done on the floor, but that's just what I'm thinking, that we don't want dueling laws or bills with respect to the same subject. Sorry, I didn't raise that earlier with you, Judge.
Okay, I'll speak to that for just 1 second. That the new section 1 in this bill, if you look at it, the Attorney General shall prepare and provide educational materials and information concerning sexual extortion as defined, blah, blah. The Attorney General shall collaborate with the State Board of Education and law enforcement agencies to educate and notify schools, students, parents, and guardians and the public about the amendments and make them available and so on. So this is asking the Attorney General to prepare and provide the materials. The bill that is in the Education Committee is called someone's bill. I'm sorry, I can't remember. Who is it? What is it? Aaron's law. And but y'all tell me if this is something different. My understanding of that is it's a mandate that the schools must teach about sexual abuse in the schools, age appropriate. But the parents can opt out. Okay, so it's a little different, it seems like to me.
And then
So thoughts on that?
it may be, I believe there's also an appropriation provision in that bill. And the two provisions may not conflict. I just haven't had a time to really sort that out. But we could, as I said, we could pass this bill as we have it. And if we decide that it's in conflict, we could, on the floor, seek to amend by striking the education provision if we so see that as appropriate.
And do you know if they're hearing and working that bill? You're on, okay, Representative Schreiber, why don't you give us an update?
Thank you, Madam Chair. So this is on Aaron's Law. We heard it yesterday, or worked it yesterday, or we're going to. The chair decided to hold off primarily because late into testimony, the child advocacy centers in Kansas came forward and said they were probably the right educators for the schools, whereas Aaron's Law didn't. They had material, but it wasn't quite clear in my mind that it was accredited and age appropriate. I can't remember the words they used. Anyway, so it was Chairman Estes held off working it because of that disconnect on who was going to provide the training. But in my mind, the CACs are more involved with the forensic investigation, whereas Aaron's Law is more about
education,
teaching kids what's appropriate, inappropriate, and if something turns out to be inappropriate, who do they tell? And then that person gets the right people involved. Probably more complicated than you need.
Okay, and then did someone over here have a discussion? Representative Barrett.
Thank you, Madam Chair. Yes, kind of to backpack off that, the Aaron's Law staff, the people that are promoting it did come and talk to me, and they said that it wasn't going to get work. They didn't believe, like, it wasn't going to make it out of committee in the House at least. So.
And you're done. Okay. Okay, well, I don't know what the will of the committee is. Representative Osman. Okay, okay, yep.
Thank you, Madam Chair. You know, just like we discussed the other day when the revisor, when there were conflicting issues and the revisor said, I cannot make the determination based on what might happen, I think that we should go under the assumption that our committee is our committee and we make the decisions within this committee, and then we figure out if another committee has made their own decisions, and then the speaker would have a choice at that point of sending them both back to a single committee, sending them on, and then we work it out in a conference committee at a later point in time, or a variety of other options.
Thank you. Representative Carmichael.
Thank you, Madam Chair. This is a good bill, and I appreciate the discussion. I don't know anything about the current discussion, but I do know that on my file folder, it says we heard this February 5th. It says it's okay, it's a good bill. Then I have a note that says needs cleanup amendments. Suggested one of my colleagues bring the amendments. Right now, I don't remember what those amendments were.
Okay.
And I know the reviser doesn't have them.
Oh, he does.
Oh, he does?
Yes, he does.
I tell you what, the reviser is so good. I have an amendment.
Great. Okay, then your amendment. Would you like to explain your amendment? Just
I would like the reviser to explain my amendment, and as soon as he says it, then hopefully I'll remember what it was. I was going to have to watch the videotape to figure it out. Thank you.
Okay, before we go to that, I just want to come back to Representative Lewis.
That's fine. I have an amendment.
You have an amendment?
Yeah.
Okay.
This is my amendment.
Oh, okay.
I hope that it's consistent with what Representative Carmichael
Okay.
I hope, Madam Chair, it's the same amendment, so I won't have to explain it.
Only the reviser knows for sure.
Okay, would you like to explain it as we're passing it out, or would you like Jason to explain it?
Jason can take the first crack.
All right, thank you, Madam Chair. So the reference was to some of the discussion from the proponents, especially the prosecutors, about maybe some needed cleanup in this bill from their perspective. And that's what we attempted to do here. So I think this probably takes care of what the other representative was talking about. You'll see the first strike there, removing the demand for anything of value from kind of the current law provisions, because that was causing a little bit of confusion about how that interacted with the elements after it. And then focusing the second part, everything starting from line 7 down to 23 on page 2, on this anything of value concept that's being added to the current crime. So you would commit this crime under the current law, and that basically doesn't change much under A1, or under A2, you would do the same things, communicate by any means a threat to distribute an image, right? With the intent to coerce such person to produce or provide anything of value, or that causes the person to produce or provide anything of value. And there's separated because there's a different penalty for coercing and a separate penalty for causing them to produce. So it incorporates the anything of value into the statute, but without complicating the current law as much as the original draft did. So that's the big amendment there. And then the amendment on page 3, I believe it was the Attorney General's office testimony that talked about how this definition of image, video, or other recording says that it includes AI sort of things and digitally altered things, but it didn't make clear what the base definition was. So I went and got the definition from some other statutes that use similar terminology, and this may look familiar. This is sort of like the conversation we had the other day on photographs and films and video pictures, et cetera. So it makes clear that that phrase means this large array of items, and it does include all of these other things that are created or altered or modified by AI. So those are the two big changes in the bill.
Representative Lewis.
Yeah, in essence, it cleans up the bill. It doesn't limit it in any way. The bill had some inconsistencies and some provisions that just didn't make sense. This does expand it from current law, and that is to say, the bill, as with the amendment, still expands this beyond current law, and I think it also increases the penalties. I'm really getting now off onto the bill. I'll just stop with the amendment.
Okay, any other questions or discussion on the amendment, first of all? Okay, would you like to move your amendment?
I'll move the amendment.
Do we have a second? Seconded by Representative Williams. Okay, so any further discussion on the amendment? Okay, would you like to close, Representative?
I'll close.
Okay, so you've heard the Lewis amendment on House Bill 2537. All those in favor say aye.
Aye.
Opposed, no. Okay, so the bill has been amended. And do we have any other amendments on House Bill 2537? Representative Carmichael.
I don't know if the reviser holds another amendment with my name on it or not. May I inquire of the reviser, do you hold such an amendment?
Do you hold such an amendment? No, he does not.
He apparently does not.
This must have been it.
Well, what I'm going to do is I'm going to go ahead and vote for the bill, but I will look at the video over the weekend, and if I find, because I think it was minor technical things, and this may have picked it up already. If it doesn't, I'll ask a floor amendment. I'll let the chair know, and if it's okay, then we'll put it on as a friendly. If it's not, then we'll just go with the bill as it is.
Okay.
I do have comments on the merits if it's the appropriate time.
Okay, yep, we're on the bill. Go ahead.
This is a good bill. I mean, I don't deny that, but we got some information from the district attorney's office in Sedgwick County, and I'm sorry, I can't remember the fine lawyer's name, and he and I have exchanged quite a bit of communication since. But I did raise concern that this bill might be too broad in some ways as it relates to what's been held to be politically protected speech. Um, and he did properly point out that politically protected speech is not, blackmail is not protected speech. But in the definitions, I think we are going too far in some ways. The case that I made reference to at the time was Falwell versus Larry Flint in Hustler magazine, where Hustler magazine, published by Larry Flint, had depicted Falwell, Reverend Falwell's mother in an outhouse engaging in sexual activity. It was a terribly disrespectful cartoon, but the court did hold that that artificially generated image of a real person in a very derogatory setting, it wasn't criminal law, it was civil law, did represent constitutionally protected speech. And I'm a vote for the bill, but someday there may be attacks on this bill along those lines, and I just want it noted that I still have that concern. And with all respect to the counselor from Sedgwick County, we were on a one question rule that afternoon, so we weren't able to really explore it. Thank you.
Okay, thank you. Any other comments about the bill? Representative Osman.
Thank you, Madam Chair. Actually, somewhat not about the bill, but a little bit. Is there a way to retroactively make an amendment on House Bill 2518 to include this definition? Just throwing that out.
We passed House Bill 20, we passed it out.
Madam Chair, the joys of looking at the same words over and over again is sometimes you find better ways to do things. So there may be desire amongst some to do a floor amendment or something on the bill that you've already sent out, so we can explore that. But that ship has sailed until it's either re-referred or dealt with on the floor.
Yeah, this could be good on the floor. Okay, Representative Barrett.
Jason, with my permission, is this the bill we were talking about doing on the floor using this language? I believe it was. Okay, yeah, so that's being covered.
Ah, it's great working together. I love it. Okay, let's, any other amendments on the bill? No. Okay, let's have a motion on the bill.
Thank you, Madam Chair. I move that we pass House Bill 2537 as amended favorably for passage.
Do we have a second? Representative Bohai seconds. Okay, and discussion on the bill. Any more discussion on the bill? Okay, seeing none, would you like to close?
Thank you, Madam Chair. I close and move my motion.
House Committee, you've heard the motion to pass House Bill 2537 favorably for passage as amended. All those in favor say aye. Opposed, no. Okay, it passed unanimously out of the House. We have one more and then we're going to be done for the day. It is a little bit of a companion bill to this one. It was the one about blackmail, House Bill 2594, if I can read my writing. 2594. And these are, as Jason explained to me, two separate crimes. And I had asked about, should we put them together? And he said it's really two separate things and it's better to keep them apart. But would you like to explain? 2594.
So, Madam Chair, yes, so just as an example, I mean, the last section was 2155. It's a sex offense. It's in chapter 21, but article 55. And this is 215428. It's a crime against persons. It's in article 54. Related topics, but not necessarily the same crime. And, you know, obviously we can bundle all kinds of criminal things down the road if we like. So don't take it as any sort of statement on single subject or anything legal. The bill 2594 deals with blackmail. Again, 215428 is the crime. And the attempt was to eliminate part of the reference to breach of privacy that is in the current law and maybe preserve part of it, and we didn't quite get there. And then also to add conduct that's not covered by breach of privacy for minors to direct coverage by the blackmail statute. So that's what the bill is trying to do.
Okay, do we have any amendments on House Bill 2594? Representative Barrett.
Yes, I do.
Would you like to explain your amendment as you're passing it out?
I'll have the revisor explain if that's okay. This will be on behalf of, this was a recommendation made by KCDAA.
Okay. Jordan, sorry. Forgive me.
We're
Jason.
both here at the same table.
Yes.
Thank you, Madam Chair. Jason Thompson again. So yeah, as the maker of the amendment is mentioning, this is kind of from the two county or district attorneys that testified. This is the sum of their suggestions. The first change in line 13, one of them suggested it needs to specifically exclude sexual contact, sexual intercourse, or conduct that is of a sexual nature to prevent overlap with the crime we were just talking about, to make clear that that is where sexual extortion and blackmail in that realm, that's sexual extortion. Blackmail of other variety is in this statute. So that's the attempt in line 13. In line 17, adding back in disseminating any image, video, or other recording obtained in violation of the one piece of breach of privacy that they wanted preserved. So that's back in from current law. And then the third change is using that term image, video, or other recording consistently in this statute. Just like we've been talking about in other bills. And then, yeah, so that image, video, or other recording, and that appears in 2 or 3 places in the bill. I do note this was before we had a definition. I don't know if we need to define it here or if that needs to be a more global definition so that it already used some of the same terms, so I didn't cross that bridge in this amendment, but we might need to cross that bridge.
Representative Barrett, did you want to say anything about it?
If it needs updated language, I'd be happy to bring anything else to it, but I would move the amendment as it is right now and then just start the conversation.
Okay, do we have a second on this? Representative Bohai seconds. Okay, conversation on the amendment. Representative Carmichael.
Thank you. It's late in the day and I'm not thinking very well. I am fit to drive home, however. It says here in line 5, which is in the title, I'm not following this, who is nude or engaged in sexual activity by changing the connection to breach of privacy? Is connection the word? And if so, maybe the revisor can explain to me what it means in context.
Thank you, Madam Chair. So in the current law, the elements of this crime are connected to the crime of breach of privacy. And
Got it.
I originally drafted as removing that connection, but we actually need to keep one connection to the crime and remove the other. So
thank you for indulgence.
That's a good question. Okay, anything else on the amendment? Representative Osman?
Thank you, Madam Chair. Can help me to understand again why we are removing sexual contact, sexual intercourse, and conduct that is a sexual nature from this. Help me to clarify, because was it too confusing with other statutes, or was there something else going on?
Madam Chair, so the request from, I believe it was Sedgwick County in this case, although it could have been the county attorney from Smith County, I can't remember, was that this would help clear up any confusion that blackmail is not the same as sexual extortion. And so those crimes are treated differently because sexual extortion has different penalties that you would potentially want to impose for that conduct. And you'll recall that over there, you're threatening to distribute an image, video, or other recording of a person that is of a sexual nature or that depicts them in a state of nudity. And over here, you're dealing with the same sorts of items potentially, but they were trying to make sure that you're not overlapping, that those two crimes don't overlap to an extent that you have to impose a lesser punishment, I think.
Okay, any other questions on the amendment? Okay, seeing none, would you like to close?
I'll close.
Okay, committee, you've heard the amendment to the Barrett Amendment on House Bill 2594. All those in favor say aye. Opposed, no. Okay, thank you. We have now amended House Bill 2594. Do we have a motion on the bill?
Thank you, Madam Chair. I move that we pass House Bill 2594 as amended favorably for passage.
Do we have a second? Representative Ward seconds. I always look this way. Representative Ward seconds. Okay, discussion on the bill. Any? Okay, would you like to close on your?
Thank you, Madam Chair. I close and move my motion.
Okay, House Committee, sorry. You've heard the motion to pass House Bill 2594 favorably for passage as amended. All those in favor say aye. Opposed, no. Okay, it is passed unanimously, House Bill 2594 as amended. Okay, that's all we have for today. Thank you. One quick thing, I want to recognize our researchers have a new pin that they're wearing that are very special. Jordan, do you have on yours? Okay, Natalie has hers on. Now you'll know when you see this special pin that has a mockingbird on it, that is from our KLRD department, and they're really cool looking if you take a look at them. So, okay, committee, that's all we have. We're not meeting tomorrow, but Monday we will have a full day. So, yes? It's a state bird. Oh, it's a meadowlark. Excuse me. It's not the mockingbird. Sorry, it is a meadowlark. Excuse me, I'm so sorry. Okay, yes. Yes, we're hearing two bills on Monday. I cannot remember what they are. What bill? Notary bill with biometrics about deed fraud and one other one. Okay. But we're working some bills too. I'll let you know which ones. Okay, we're adjourned. Thank you. I guess we're adjourned since everyone's gotten up.